Donald Trump submits a monster motion to dismiss his case. This one's coming out of Washington, D.C. The circuit court with Judge Chutkan, who's been presiding over this case, some might say in a biased manner. And we now have a big whopper motion that we've been expecting for some time. And I think this one really has some heft to it. This is a case of first impression, never been decided before. And there's going to be a lot of conversations about what it means. Coming out of the District of Columbia, you can see it was filed on October 5th, and it says, the motion to dismiss indictment based on presidential immunity. And so here's what Trump's defense says, starting off. Your Honor, Judge Chutkan, President Trump moves to dismiss the indictment in this matter with prejudice, meaning this thing is not coming back again, based on presidential immunity. In support, President Trump states as follows. The President of the United States sits at the heart of our system of government. He is our nation's leader, our head of state, and our head of government. As such, the founders tasked the President and the President alone with the sacred obligation of, quote, taking care that the laws be faithfully executed, citing the United States Constitution, Article 2, Section 3. The one guy, the primary source of power under the executive branch. To ensure that the President may serve unhesitatingly, without fear that his political opponents, that they may one day prosecute him for decisions that they dislike, like beating them in 2016. The law provides absolute immunity, says Trump's defense, for acts that are within the, quote, outer perimeter of the President's official responsibilities. And what they're citing is this case, Nixon versus Fitzgerald. And this is a big case, all right? So, and here, this was a prior case where the President was decided to be immune from prosecution, but it was a civil lawsuit, right? So civil versus criminal. Trump is being prosecuted criminally. And here they're saying the President is immune from being in a civil suit. Now you might ask yourself, well, what is big Letitia James doing over there in New York? Well, she's not prosecuting Trump for his presidency. She's prosecuting him because she's just a partisan prosecutor hack, and she's going after his businesses, right? So in this case, the question was Fitzgerald, back then, he was a civilian analyst. He was at the U.S. Air Force. He testified before a congressional committee, and 1 year later, he was fired, right? So this guy shows up in Congress, blasts the administration. Nixon fires him. Nixon says, yeah, I did it. So then Fitzgerald sued Nixon. And he says, you can't fire me, after the Civil Service Commission concluded that he was unjustly fired, like there was no firing for cause. Nixon did it anyways. So he sued him. You can't sue me. Guess what? The Supreme Court said, yes, we can. 5-4 decision for Nixon. Very close, okay? Like not a unanimous decision in any way. So the court said yes. The court held that the President, it's still precedent. This is still in existence. So if the court is going to do something, they're going to have to overturn this, to reverse this, right? But the question is this going to apply to criminal? But back then in the civil case, the court held that the President is, quote, entitled to absolute immunity from damages liability predicated on his official acts. This sweeping immunity, argued Justice Powell, was a function of, quote, the following: the President's unique office rooted in the constitutional tradition of separation of powers and supported by our history, which is exactly right. Okay, the President's office is unique. They keep saying to us, no one's above the law. And it's like, I know it's not kind of acceptable to admit this from our side, is to say, actually, yeah, the President is kind of above the law. That's why they are the President. They have the pardon power. They have the opinion clause power. They have all sorts of other powers that nobody else in the whole world has, okay? So they are kind of actually above the law. But it's a stupid talking point that the left wants to say. And if you're on the right and you say, well, you say Trump is above the law? Yeah, I do. They're like, oh, you're a tyrant. You go, do you understand the Constitution and how it works when you have separation of powers? If Congress can legislate something that makes the President subordinate to Congress, who's in charge? Who really has the total power? Obviously Congress would. So it is not separate and co-equal. So anyways, they don't understand the Constitution, which is why they're liberals. But the point, all right, that's the case. Now, back over to the filing. They say, Your Honor, Judge Chutkan, breaking 234 years of precedent, the incumbent administration, Joe Biden, has charged President Trump for acts that lie not just within the outer perimeter, not within the hula hoop, but at the heart, right in the middle where the person stands, of his official responsibilities as president. In doing so, the prosecution does not and cannot argue that President Trump's efforts to do what? To ensure election integrity, that's it, and advocate for the same were outside the scope of his duties. In fact, that's what you want the president to do, is to make sure we have fair elections, right? Instead, Joe Biden's prosecution with Jack Smith falsely claims that President President Trump's motives were impure, that he purportedly, quote, knew that the widespread reports of fraud and election irregularities were untrue, but he sought to address them anyways. Like, he made up this whole thing. What we all saw happen in real time. The next morning, okay, we were here live streaming on election night. We went to bed like, well, that's it, in the bag, Trump won. Dirt. Woke up the next morning, we saw all the charts that looked like this. They went like this: Biden, 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 Biden. What? And Trump's was like this, right? And Trump went like this. We go Biden, Biden, Biden. What the heck is going on here, man? So we woke up and the whole thing flipped. Then we learned that ex-CIA agents were involved in the Hunter Biden laptop cover-up. Then we learned that the FBI, with agents like Elvis Chan, were censoring Americans and their free political speech. Trump knew that. We all knew it. We're all sitting here saying, why did Tony Bobulinski get thrown off the air? But anyways, as the Constitution, says Trump's defense, and the Supreme Court in hundreds of years of history and tradition all make clear, Trump's motivations are not for the prosecution or for this court to decide. It's, he's the president. You don't get to say he should have made a better decision and believed us. He doesn't have to believe you. He's the president. You might disagree with that. You might say, well, you know, all of the federal bureaucracies lied and said that it was all fair and free, and Jake Tapper was on CNN, and so maybe you should believe it, but that's not for Trump to do. So rather, whereas here, the president's actions are within the hula hoop, he is absolutely immune from prosecution. You don't get to question his judgment by substituting yours. And they say, Your Honor, here's the legal standard. In ruling on a motion to dismiss, which is the one before you, you've got to do certain things, and we'll fast forward through that. But they say, all right, Judge, here's the plan. We're going to give you some examples of what is alleged in the indictment, starting with the following. President Trump, the incumbent administration's, in parentheses, leading opponent in the upcoming presidential election, in case you didn't know that, Judge Chutkin, emphatically denies the truth of any allegations in this indictment, rejects all of them. Rather, the memo sets forth the facts alleged in the indictment so that their legal sufficiency may be assessed in a motion to dismiss. So they're saying, Your Honor, we think that each one of these small, minor, zoomed in elements that's required to bring the case, they're all factually insufficient. We're going to go through them one by one and show you why. And we have to do that because in order for you to grant our motion to dismiss, you've got to take a look at all the elements. That's what the law says we've got to do. So this motion addresses only the question of presidential immunity. Other deficiencies that are fatal are going to be addressed later. Motion to dismiss version 1. You're going to be seeing seasons 2 through 35 coming up very soon. They say, Your Honor, the indictment in this case from Jack Smith and Joe Biden alleges that President Trump took a series of action that formed the basis of its charges. He did a bunch of things that were all illegal, and they put him into 5 categories. The indictment alleges that Trump, while he was still president, did 5 things. 1, he made public statements about the administration of the election. Okay, so he said a couple things, and he posted tweets about the administration. We got to be very clear. What is the conduct? So he made some statements. He then communicated with the Department of Justice about investigating election fraud and about choosing the leadership of the DOJ. Can the president tweet things and talk about federal elections? Is that within the hula hoop? Yes, obviously. Is investigating election fraud within the hula hoop? Obviously. Does the president get to decide the DOJ leadership? Yes. Number 3, they say that Trump illegally also communicated with state officials, so federal and state, maybe state officials, about the administration of federal election and the exercise of official duties with respect to it. So they were working in, Brad Raffensperger was not, Trump wasn't calling him about a Georgia Senate seat that was a state Senate seat. He was calling him about a federal election. And he wasn't asking him to do anything fraudulently. He was just saying, I have questions about how it was conducted and investigate it, which is within the purview of the hula hoop. 4, communicated with the vice president. In his legislative capacity as the president of the Senate, Mike Pence had a role to play. Trump could talk to him in that role. And with other members of Congress about the exercise of their official duties regarding the election certification. President talks to Congress people. Happens all the time. And number 5, authorized or directed others to organize contingent slates of electors in furtherance of his attempts to convince Mike Pence to exercise his official authority, which he had at the time, right? They changed all of his official authority after the fact, which means he had it in a manner advocated for by President Trump. Now, I think that they're going to say this is the biggest problem of all of them. They say that all of them are illegal. That's why they're all categorized. But all of these things are, as we've covered here, perfectly within the scope of the presidency. Even this last one, I think, is absolutely within his purview because Democrats have done it repeatedly. We've seen it before. They did it in the 1960 election in Hawaii. What happens is when there is a contested election, until recently, now everybody's being charged with felonies, so I don't know how it's going to happen this next time. But if there is a contested election, both sides declare victory. They both proffer up their people and they say, if it goes our way, if there's a recount and we reverse this thing, our our people get slotted in. Has happened many times in this country until Trump did it. Now it's illegal. Everybody's charged with a felony because Democrats are prosecuting them all across the country, and particularly Michigan and elsewhere. So here they say public statements and tweets. First, Jack Smith, Your Honor, Chutkin, alleges that President Trump, while he was still president, made public statements about the 2020 election. And they're referencing a bunch of examples. They note for us, though. They say, Your Honor, by the way, just as we're clear as we're going through this, in certain cases, the indictment does not even specify whether Trump had direct involvement in many of these actions or even knew they were occurring. So they're giving us certain acts and we can't even connect them to Trump. But they say, even assuming that he did, the acts alleged are still all of a public character. They're still all within the hula hoop. And here they're referencing all the different statements, right? Trump's public statement in a speech about Mike Pence, Trump's public speech on January 6th, Trump's about the vice president's authority, and they're just articulating all the different locations where Trump's statements have come up throughout the indictment. Closely related, says Trump's people, to the allegations of the public statements, the indictment also says that Trump posted a bunch of illegal tweets, and he's articulating those. This tweet urged Americans to protest fraud. Another tweet about the vice president's authority about election certification proceedings. Another tweet urging protesters to stay peaceful, saying no violence, all right? Are those things illegal? Can he say those things? Here is another category, right? So the tweets and the public statements. The next category, working with the DOJ, Jack Smith says illegal. The indictment also alleges that Trump attempted, their words, Jack Smith, to use the power and authority of the DOJ to conduct election crime investigations and to send a letter to targeted states. And he claimed that the DOJ had identified significant concerns. Trump's defense says, well, Jack Smith alleges that there were a series of meetings and communications that took place. Trump met with DOJ people, all related to fraud, and Trump was considering appointing a new acting attorney general and other things. Okay, all of these are the specific actions. Phone calls with acting attorney general. We read through the full indictment, so it's just mirroring the indictment. If you missed the full indictment, we read through it all. But they say here, yeah, multiple calls. Deputy White House counsel, senior advisor, all of these things. And you'll notice is look at all these official names. Okay, and the attorneys are doing this by design. DOJ official was meeting with the acting attorney general, office of legal counsel, deputy attorney general. We have phone call with the acting AG. All of them are all official people to call and coordinate these things. It's not like he's like coordinating with the mob to conduct fraud. He's investigating the fraud with the formal mechanisms that are at the government's disposal, literally within the power of the presidency. Next bucket, communications with state officials. Oh no, Trump talked to people at the state level. The indictment alleges a series of communications, some by Trump and some by others, with state officials about the administration of, once again, a federal election. Bunch of phone calls, called Arizona House of Representatives, called Georgia Attorney General Brad Raffensperger, talked to the majority leader of the Michigan Senate, met with Pennsylvania. Next bucket is where he talked to Vice President Pence, again, articulating all of the elements in the indictment. The indictment, Jack Smith alleges multiple conversations with Vice President Pence, in particular about his role as the Vice President of the Senate, constantly urging Pence to, quote, use his ceremonial role to overturn the results of the election, is what the indictment alleges. In addition to communications with Pence, the indictment also alleges a number of communications with other members of Congress and U.S. senators and U.S. representatives and so on. And then lastly, before we unpack all of this, Trump tried to convince alternate electors who are now being charged with felonies in multiple states. Closely related to these communications with Pence and other members of Congress, the indictment alleges that other individuals organize slates of contingent electors from several states to substitute them in. According to the indictment and Jack Smith, these contingent electors allowed Trump in his communications with Pence to justify Pence's authorities to decertify, right? So the alternate electors, they're saying Trump brought those up to tell Pence, just pick them. The indictment alleges that Trump knew of these actions organizing these electors and directed them to continue, but it does not allege that Trump took any particular action in organizing them. All right, now, with that foundation out of the way, what it sounds like to me is a bunch of different buckets, 5 different buckets of protected content and conduct. The president was exercising his power to investigate what we know now was an election filled with fraud. So here's what his defense says. The president has absolute immunity from criminal prosecution for actions performed within the outer perimeter of his official responsibility. Now, as we know, when we have a hula hoop, hula hoops are not just a point in space. They're actually some thickness to them. And so now our question here is, what type of conduct is right in that like inch or so? What conduct is in that little question questionable gray area. There's some stuff that's clearly inside, and there's some stuff that's clearly outside, like shooting somebody in Fifth Avenue. But what about the border of the hula hoop? The question is, if it is the gray area, Trump's people say it's the outer perimeter of the hula hoop. You get all of the interior of the plastic. They say, referencing back to the Fitzgerald case, the one that we read previously, they say, in view of the special nature of the president's constitutional office and his functions, a current or former president, they're referencing a Supreme Court case here, has, quote, absolute presidential immunity from civil damages for acts within the outer perimeter of his official responsibility. Now, no court in this country has addressed whether such presidential immunity includes immunity from criminal prosecution. It's new, it's novel, we don't know. For a president's official act, okay, official, not shooting somebody on Fifth Avenue as the left would have you say. The question remains a serious and unsettled question of law, and it looks like they're citing that back to the Supreme Court case. They said that here, in light of the special solicitude due to claims alleging a threatened breach of, in addressing this question, Trump's defense says to Judge Chutkan, Your Honor, this court should consider the Constitution's text, the structure, the original meaning, the historical practice, and the court's precedents and immunity doctrines and considerations of public policy. That's a lot of meat here. This reminds me of a Supreme Court brief. Okay, these arguments I think are going to just be re-emerging at the Supreme Court at some point. Now the question is going to be what happens here, and of course we'll get to that later, but Chutkan is very likely going to deny the motion to dismiss. Can Trump appeal it? Certainly. Will it be certified for appeal? Certainly not. And so at the end of a trial is more likely when we'll see an actual appeal. But Trump's people continue. They say, Your Honor, this is pretty clear. The doctrine of separation of powers, separate and co-equal branches of government, and the president's unique role in our constitutional structure require immunity from criminal prosecution. How do we know that? Well, the whole system is going to fail if we don't have it. They say here from the Supreme Court, and they're almost writing for the Supreme Court. It's like, hey, Supreme Court, by the way, the president occupies a unique position in the constitutional scheme. No doubt about it. That's why everybody wants to be the president. They say it's the most powerful position in the whole world for a reason, because it is this ultra unique position. They say Article 2, Section 1 of the United States Constitution provides the following, that the executive power shall be vested in a president of the United States. And it doesn't say the office of the president. It doesn't say anything other than a president. Okay, it is a singular person. This grant of authority establishes the president as the chief constitutional officer of the executive branch, entrusted with supervisory and policy responsibilities of utmost discretion and sensitivity. And due to this unique status in our Constitution, where we have a separation of powers, this distinguishes him from all other executive officials. He is not the same as everybody else. This is according to the Supreme Court. They held in Fitzgerald that the president is and must be absolutely immune from damages liability predicated upon his official acts. They reached this conclusion because they reasoned to it. They said, look, subjecting a president to personal liability for his official actions would improperly divert the president's energies, and it would raise unique risks to the effective functioning of government, especially given the singular importance of the president's duties. If you can just allow people to file lawsuits against somebody who was the president, that would divert the president's energies. Does that seem like it's happening right now, literally everywhere we turn? That's the whole point. Everything the Democrats are doing is in violation of this case law. It's Tishy James, it's Big Fannie Willis, it's Alvin Bragg, it's Jack Smith. They're hitting him every which way you can possibly go. And they're doing it criminally. And Tish is doing it civilly for a claim that precedes any of his running for president. So this just makes sense as a matter of practicality when you just think about it as a matter of public policy. Chief among the risks, Judge Chutkan, is the chilling effect that personal liability would have on the presidential decision making. When the president does something, you know, it's going to arouse pretty intense feelings, and we want to make sure that the president has the maximum ability to deal fearlessly and impartially with the duties of his office. You can't just have a president walking on pins and needles, lest he be sued. So they say, Your Honor, although Fitzgerald concerns civil liability, the exact same thing here, if not more elevated, the same concerns apply to criminal prosecutors, and it mandates the same absolute immunity. The same reasons we said that this applies in civil cases, they still apply here. This is even more serious. If we didn't want presidents president's being harassed by ex-civil servants, we definitely don't want him being harassed by partisan elected prosecutor hacks. They say vertical and horizontal separation of powers simply cannot permit local, state, or subsequent federal officials to constrain the president's exercise of his judgment through threats of criminal prosecution. All right. At the federal level, we have horizontal separation of powers. You got the executive branch. They're just as powerful as the judicial branch. Same level. The legislative branch, same thing. Separate, co-equal. But vertically, now you've got the states. And so if the states can come in and now through Fannie or Tish or Jack Smith, although he's a federal level, if they can usurp and use criminal charges, or if any prosecutor can use criminal charges against the president, that undermines the power of the president. So to hold otherwise would allow the president's political opponents to usurp his or her constitutional role, fundamentally impairing our system of government. It's like dividing by zero. It doesn't work. So for this very reason, the Supreme Court, in the case of Fitzgerald, recognized that presidential immunity is not just a creature of common law, but also rooted in the separation of powers under the Constitution. They say, nothing is so politically effective as the ability to charge that one opponent and his associates are not merely wrong-headed and naive, but really crooks, coming from Judge Scalia. And nothing so effectively gives an appearance of validity to the charges as a DOJ investigation, or even better, a prosecution. Amazing quote from Judge Antonin Scalia, rest in peace, one of the greatest of all time. Exactly right. He hit it exactly on the head. 1988. He's rolling in his grave today. Nothing is so politically effective as launching a DOJ investigation on your political opponents. Supreme Court judge wrote that in 1988 in the United States Supreme Court. The president provides ample means for that sort of attack, assuring that massive and lengthy investigations and prosecutions will occur, bedeviling every future presidential administration and ushering in a new era of political recrimination and division, which we're living through right now. They say, analogically, the executive privilege protecting presidential communications is also designed to protect the president as well. So they say, Your Honor, Judge Chutkan, presidential immunity from criminal prosecution for official acts is also rooted in the text of the Constitution. Let's look at it. The impeachment clauses provide that a president may be charged by indictment only in cases where the president has been impeached and convicted by the trial in the Senate. And guess what, Judge Chutkan? Trump was acquitted by the Senate for the same course of conduct. He's already been indicted when Nancy Pelosi's House of Representatives impeached him for the second time. And the Senate already acquitted him. We've already had a trial on this. The impeachment clause of Article 1 provides that judgment in cases of impeachment shall not extend further than to removal from office. But the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to the law. And look where they got that from. Is this a United States Code statute that Jack Smith cited in his indictment? No. It's the Constitution. Article 1, Section 3, Clause 7. And if we just zoom out on this, they're saying, look, if you get impeached and you get convicted, then it's fair game, all right? If you get convicted, see this ED, convicted, which Trump never was, you shall nevertheless be liable and subject to the other criminal prosecution proceedings, right? Indictment, trial, judgment, and punishment. But Trump was already tried and he was not convicted. So therefore, what this implies, and what I think it means, or if you think honestly and logically, is that all of this section here, indictment, trial, judgment, all of that is not allowed. Why? Because this phrase, which is a necessary phrase, the party convicted shall nevertheless be subject. And since Trump was not convicted, the same conduct here, no charges. They say the Constitution specifies that only the party convicted, ED, shall be liable. It presupposes that a president who is not convicted may not be subject to the prosecution. And look, they're writing this for the Supreme Court. You can see it here. They're even telling Judge Alito, who's sitting on the bench right now. Hey, as Justice Alito recently noted, as in 2020, in a dissenting opinion, okay, so they're talking to him, but this came from a case where he was not in the majority, meaning that this, whatever the statement is not law yet, but maybe this will be applicable in this case. As Alito recently noted, the plain implication of this clause is that criminal prosecution, like removal from the presidency and disqualification from other offices, is a consequence that can come only after the Senate's judgment, not during or not prior to the Senate trial. Trump versus Vance in 2020. So anything Jack Smith is doing or Fannie's doing is precluded. because he was not convicted. And the Constitution, which is the supreme law of the land, it surpasses everything else, says this is the proper mechanism when somebody is alleged to have broken the law. And so you can go right back to our Fifth Avenue example. Okay, if Trump shot somebody on Fifth Avenue, he would be impeached and convicted for murder. And then what would happen is he would be indicted and prosecuted and imprisoned for murder. But that's not what happened here. And we're not even to the juice of that yet. So they say this was how Alexander Hamilton explained the impeachment provisions in the Federalist Papers. He wrote that a president may be impeached, tried, and upon conviction would afterwards be liable to prosecution and punishment in the ordinary course of the law. He wrote that in Federalist Papers number 77. He said in there, a president is at all times liable to impeachment and trial and dismissal from office, but any other punishment must only come subsequent in the common course of the law. It's got to come after. And they didn't get any convictions. Scalia also wrote about this in 2012. Rest in peace. He wrote in the interpretation of legal text, he gave us an analogy. He says, when a car dealer promises a low financing rate to purchasers with good credit, it is entirely clear that the rate is not available to purchasers with spotty credit. Okay? So he's saying you can imply the negative of that. Car dealer comes in and says, hey, we'll give you low financing if you've got good credit. Anybody can infer if you don't have good credit, you're not going to get low financing. Same story here. Now they give us some more examples. This is an excerpt from the Clinton versus Jones case. They said here, James Wilson, who was somebody who had participated at the Philadelphia Convention where the Constitution was drafted, explained that the president is amenable to the laws in his private character as a citizen and in his public character by impeachment, right? Just that same distinction that we talked about at the outset. Fitzgerald, the Supreme Court case, also reaffirmed this. And they explained, what's the difference between public character? What's the difference between President Trump and candidate Trump? His official acts, the president may be disciplined principally by impeachment, not by private lawsuit, but he's otherwise subject to the laws for his purely private acts. All right, so another distinction. So a rule, and here, the Supreme Court confirmed all of this as well. They said, a rule of absolute immunity for the president will not leave the nation without sufficient protection against misconduct. That's what you hear on the other side of this. Oh, I guess that Trump can just do whatever he wants then, and the nation can't do anything about it. No, there remains a constitutional remedy of impeachment. It exists right there. In addition, there are formal and informal checks on presidential action. The president is subjected to constant scrutiny by the press, and now criminal prosecutions if you're Trump. Vigilant oversight by Congress, unless you're the Republicans in Congress, and they can just let the Biden people do whatever they want. Also may serve to deter presidential abuses of office. Not really. I kind of disagree with this paragraph. Here, other incentives to avoid misconduct may include a desire to earn re-election. That's true. Right, that I absolutely agree with. Let the people decide. If Americans really think Trump insurrected America, well, they're not going to vote for him, right? I mean, I think Americans believe in free and fair elections. So can we just vote on it? Or do you have to throw him in prison? How about that? The need to maintain prestige is also an element of presidential influence and the president's traditional concern for his historical stature. All of these are other checks and balances. Yeah, Congress doesn't do anything to deter presidential abuses now. Yeah, they were very aggressive against Trump. They impeached him twice, for crying out loud, but it only works one way. So the point is, we got to preclude that from happening. So they say, now notably absent from Fitzgerald's list of formal and informal checks is any mention of criminal prosecution. All right. So in other words, all of these other things are allowable. We can vote or not vote for a president if you don't like the guy, but prosecuting him is not on the list of things that's allowed. Here, Trump's defense says President Trump is not a party convicted, hasn't been ever convicted in impeachment trials by Senate. In January 2021, he was impeached, no doubt, on charges arising from the same course of conduct that are at issue in the indictment. President Trump was acquitted of these charges after a full trial in the Senate, and thus he remains immune from prosecution. So the special counsel, through Jack Smith, cannot second guess the judgment of a duly elected United States Senate. We've already gone through the process. It's already been decided. They tell us, Your Honor, going all the way back to one of the most important and early cases in American jurisprudence, Marbury versus Madison. Charles Lee, in that case, Attorney General of the United States under Presidents George Washington and John Adams, he said, declared it to be my opinion, grounded on a comprehensive view of the subject, that the president is not not amenable to any court of judicature for the exercise of his high functions. This is the Attorney General under George Washington and John Adams saying the president is basically not subject to the court's jurisdiction, okay? Like any other court, not amenable to any court of judicature for the exercise of his high functions. He's describing immunity in a different language. The courts have no jurisdiction over him, but is responsible only in the mode pointed out in the Constitution. The method, through impeachment, trial, and conviction by the Senate. Talked about that. In his opinion for the court, the Chief Justice Marshall endorsed this view. He says, by the Constitution of the United States, the president is invested with certain important political powers in the exercise of which he is to use at his own discretion. You don't get to substitute yours in, Jack Smith, and is accountable only to his country in his political character and to his own conscience. The people can decide what to do about it. In cases involving the president's official duties, Marshall said, whatever opinion may be entertained of the matter in which executive discretion may be used, still there exists and can exist no power to control that discretion. If you limit the president in any of those ways, it's not co-equal. The subjects are political, and we leave the check to the people to make their decision. You don't like it, vote them out. Penalize the next person and the party. And that has happened before. So they respect the nation, not individual rights, and being entrusted to the executive, the decision of the executive is conclusive. The acts of such an officer as an officer can never be examinable by the courts. Again, just totally without jurisdiction. So Trump's people say, when the president acts in cases in which the executive possesses a constitutional or legal discretion, nothing can be more perfectly clear than that their acts are only politically examinable. They have the discretion. They can make bad decisions. The president can make a bad judgment call, and you might disagree with it, or make a good judgment call that you disagree with. But the consequences for it are political. If the president acts in a case in which the discretion is to be exercised, any application to a court to control that conduct would be rejected without hesitation, because that would make the court more powerful than the president, or that would make Congress more powerful than the president. And I make the same argument. We're in the January 6th case right now, but I make the same argument for the Florida case. The president has opinion clause power. He has the sole root power to all the classified documents in the whole stinking country if he wants them, because the Constitution says that. And so Trump, by virtue of that fact, is also immune from being in possession of classified documents, and also for the allegations of obstructing the return of those classified documents. Congress can't tell him that you have to comply with some classified document crap, because he's the president and he has opinion clause power over the whole structure. Same thing is emerging in this case as well. And even if they did have a problem with that, they should have impeached him over it first, and they didn't do that. So here, Trump's defense give us an excerpt. They say, Justice Story, another judge, cited Marbury versus Madison, and he made another point in a very common treatise from 1833, talking about the president. This one came out in 1833. There are other incidental powers belonging to the executive department, the presidency, which are necessarily implied from the nature of the functions. Among these must necessarily be included the power to perform them. So if you're given a power to cause an outcome, then you've got to be able to actually do the thing to lead to the outcome. You can imply and infer that without any obstruction or impediment whatsoever. So the president cannot therefore, if you can infer those powers, be liable to arrest or imprisonment or detention while he is in the discharge of the duties of his office. And for the purpose, his person must be deemed, in civil cases at least, to possess an official inviolability. Now, in the exercise of his political powers, the president, he is to use his own discretion and is accountable only to his country and to his own conscience. His decision in relation to these powers is subject to no control, and his discretion when exercised is conclusive. That's it. Liz Cheney doesn't get to question Donald Trump. She doesn't get to insert her judgment for his. So for Jack Smith to say, well, maybe he should have agreed with us that the election was free and fair, he doesn't have to do that at all, not one bit. That's the power of the presidency. Trump's defense says likewise, when the president exercises an authority confided into him by law, his conduct cannot be second guessed by a jury because they are his facts, and the jury doesn't get to substitute their own decision for the president's decision. That's a political question for the people to decide. So Trump's defense says 234 years of history and tradition support this argument. In the prior Supreme Court case of Nixon versus Fitzgerald, the Supreme Court emphasized that the presuppositions of our political history, including traditions grounded in history history and reason define what presidential immunity means. We've had in this country 234 years of unbroken historical practice from 1789 until 2023. And that history, that 234 years, it provides compelling evidence that the power to indict a former president for his official acts does not exist. I know that MSNBC and everybody on the left says Donald Trump is the worst thing that's ever happened to history of America. But my friends, I've been alive not that long where I've seen this before. They said all of this same stuff about George W. Bush. They said he was Hitler, that this was a war for oil. We had Cindy Sheehan crying all over the place every day when I was in school, crying that this guy was a monster. Even the insane lefties back then didn't indict him, all right? It's been the same story. We've had many other presidents who've done some things that people might consider to be monstrous conduct. We've had political battles with people being shot and caned, okay, in Congress. Assassination attempts. We've had political strife in this country that resulted in a civil war, right? But the whole point is, right, 234 years we've never gotten here. And now we are. Boom. Here we are. Joe Biden and the Democrats sweep into power and they decide, well, we're not going to lose again, not to this guy. And so the FBI, the DOJ, Jack Smith, Joe Biden, everybody circles the wagons and they prosecute him. No prosecutor, federal, state, local, has this authority, and none of them in the prior 234 years has ever sought to exercise it until now. It is a break glass in case of emergency situation for them. It doesn't exist. They've never done it before with good reason. Are you telling me that no other president before has done anything criminal before? And so that this is like the first time that ever a president did something criminal, like, oh, we're just going to go prosecute Trump. Give me a break. It's a political hit job. They know it. And they're doing it because their side is losing, right? The world's at war. The country is in economic oblivion, as we're all experiencing, and they're losing at the polls. So they say American history, from Trump's defense, teems with situations where the opposing party passionately contended that the president and his closest advisors were guilty of criminal behavior in carrying out their official duties. In fact, John Quincy Adams, they said that he had a corrupt bargain with Henry Clay. They say it provides a notable example. There was a whole deal where they said there was a corrupt bargain to install other people in the House of Representatives, back when John Quincy Adams was the president. And everybody since the original founding of this country has been claiming the other side are a bunch of crooks and criminals, but nobody's prosecuted them. In every such case, the outraged opposing party eventually took power, yet none of them ever brought criminal charges against a former president based on the exercise of his official duties. Nor did any state or local prosecutor of the thousands of other officials throughout the history of this country and the tradition of America ever attempt a similar maneuver. Now, a strong historical practice of not exercising a supposed power, especially when there's been ample incentive and opportunity to do so, undercuts the sudden discovery of this newly minted power. Wow, it just popped up out of nowhere. Constitutional practice tends to avoid that. We don't just discover new powers unless you are, again, a Democrat. They discovered another one, which is keeping Trump off the ballots under the 14th Amendment. So they say here, analogous immunity doctrines also support immunity. Civil suits is one example. Judicial immunity is another concept. Absolute judicial immunity also protects judges from criminal prosecutions. Okay, if judges are protected from criminal prosecutions, wouldn't it make sense that presidents are too? In accordance with long common law tradition, our courts have universally rejected criminal charges against judges for their judicial acts. Don't allow it. Here, in reaching this conclusion, they extensively reviewed historic authorities and other authorities, and they determined criminal prosecution of judges for judicial acts would destroy the independence of the judiciary, and it would mark the end of an independent and a fearless judiciary, right? So judges are immune. They say the same reasoning applies to the president. They also talk about public policy now, and I think this is a good topic to zoom in on. Think of the consequences of this, and this is something that we've paused on a lot here. Once one side decides that they're not going to play by the rules anymore, the other side has to also not play by the rules, otherwise they are limited, okay? Their hands are tied behind their backs. If the Democrats are going to be censoring people and deplatforming people and demonetizing people and then prosecuting people and using the FBI and the DOJ and the entire Department of Justice and their prosecutors to imprison people, and the Republicans are just sitting here and they're like, well, we're not going to stoop to their levels and we're just going to keep playing a fair game, right? They will get obliterated and be gone, and we'll live in a one-party system, which maybe that will be the future. We don't know, which I think will ultimately result in a partition of the country or whatever, but that's a whole separate video. The point point is, what happens when this is the new standard? If the Republicans don't do the same thing, they will be gone. Meaning, at some point, might be 2 years, 5 years, 10 years, they're going to have to start prosecuting the other side, which is why nobody does this, because it is the same as mutually assured destruction. Both sides now have the nukes. Democrats launched one. The Republicans are going to have to do one back. It is a problem, which is why the court should step in and fix this. The court should stop Jack Smith and the executive branch and the irresponsible criminal Biden crime family from exploiting the laws to protect their butts in the White House. The court should say this is obviously an overstep. The president is immune. So they say in considering presidential immunity, the Supreme Court has weighed concerns of public policy as illuminated. And here, public policy overwhelmingly supports the finding of immunity. And you might say there are people I've seen say things like, well, maybe Trump should have prosecuted Hillary, right? Because what happens is, well, people say there's a double standard here. Trump's being prosecuted, Hillary wasn't. Well, they say, well, Trump promised to prosecute Hillary, maybe he didn't. And my response to that is maybe he got into office and he realized it is mutually assured destruction, right? It is turning the key in a way that you cannot undo. And he didn't do that. And that goes to Trump's credit. Should not ever be used as a response the other way. Okay, Trump may have said a bunch of stuff, but when he got in there and he made this decision, he looked at 234 years of history and he said, okay, maybe we won't do it. But now they did it. In hindsight, maybe Trump should have done it, but that's not what happened. And they broke the seal. So now the presidency involves especially sensitive duties, obviously. Trump's defense writes, first, Your Honor, Judge Chutkan, the Supreme Court emphasizes the necessity of robust immunity for officials. We saw that in Fitzgerald. And no one exercises more sensitive duties than the president. Under the Constitution, we know the president has discretionary responsibilities in a wide variety of areas. And immunity, as explained, reaches all of the president's conduct, including his numerous and innumerable dimensions. In all of the contexts, the scope of the power is broad and the scope of immunity is broad. It extends to cover the same level of power that the hula hoop has. The president, in order to do the job of executing the laws, needs to be able to actually do the job. So it requires bold and unhesitating action. They say the Supreme Court reasons that immunity is most appropriate from officials when we want them to take bold and unhesitating action. We don't want our elected officials to tiptoe over making decisions lest they be sued or prosecuted by Big Fanny. Now, they say the Supreme Court has emphasized if anybody in the executive department is placed in a position where they are under an apprehension that the motives that control his conduct, if they say, if you can question his motives, then it would seriously cripple the proper and the effective administration of that role. And so the president and his focus should not be blurred by the subconscious knowledge of the risk of future prosecution. They say another key purpose of immunity is to stop officials from being harassed. We don't want anybody being harassed by prosecutors unless, of course, they're Trump. And so MSNBC is saying about this, but now and talk about the specific conduct that is at question. And listen to MSNBC explaining their reaction when this motion got filed. Here is what they sounded like.
Former President Trump has filed a motion to get his federal election interference indictment dismissed. We just got our hands on it, 52 pages. NBC's Ryan Riley has been looking at it. What does the document say?
You know, essentially what they are arguing here is that the scope of his duties included what he was doing around the election. Essentially that he did really believe these things around the election, effectively that he was high on his own supply here, and that he didn't have impure motives, that he actually was trying to go to address questions of election integrity, and that's what he was doing in the scope of his duties. They want to say that this was all about what he was responsible for doing as president. This is not chargeable conduct because this was part of his job as president. He was actually upholding his oath of office here. So they're sticking with that idea that he actually did believe this. Of course, there is a long history of Donald Trump believing false claims about the election. Of course, infamously in 2016, he refused to concede that he lost the popular vote, even though he obviously won the Electoral College and said that there were millions of fraudulent votes in that case as well. So there's an established history they can lean on here, but essentially saying that this case cannot be brought forward because Donald Trump was doing his duties as president. So expect, obviously some very firm opposition and some strong arguments coming back from the special counsel's office when they get a chance to take a whack at some of these these arguments.
All right, so they will. Jack Smith will be back, and we'll see what they say. But you can see they're saying that Donald Trump is just making it up, that he should have known, he should have listened to all of the other officials. Everybody came out and said, Trump, you lost. Get out of office very quickly. Very clear. And for him to respond and try to investigate it, they say was improper. But as we just read, going to be difficult for them to make the case that they can substitute their argument for the president's because they are not the president. So Trump's defense continues. They say the indictment alleges only acts committed within the core of the president's official responsibilities, and those acts are shielded. Okay, so let's break that statement down. What Jack Smith indicted Trump for is only talking about conduct which are literally shielded. So we zoom in. The indictment from Jack Smith is based entirely on alleged actions within the heartland of President Trump's official duties, or at the very least, within the outer perimeter of his duties. And therefore, Trump is absolutely immune from criminal prosecution from those acts. The court should therefore dismiss. They say. Now, what is the outer perimeter? The Supreme Court adopted an expansive outer perimeter test for immunity precisely because any functional test would be inconsistent with the broad scope of presidential duties. In other words, the outer perimeter of presidential duties, and thus the scope of presidential immunity, like a force field, it encircles a vast swath of territory because the scope of the president's duty and the authority in our constitutional system is uniquely and extraordinarily broad. Article 2 makes a single president, one person, responsible for the actions of the executive branch, and the president is the only person who alone composes a branch of government, the whole branch. It's a very unique position. Among these Article 2 duties that the president has to do, perhaps the most fundamental are the framers' dual mandates that they hold, quote, the executive power, and with it, quote, the duty to take care that the laws be faithfully executed. Referencing the United States Constitution makes my heart warm. To this end, the president must assume supervisory and policy responsibilities of utmost discretion and sensitivity, which includes the enforcement of the federal law, meaning the president's duties range from a bunch of things: faithfully executing the laws, commanding the armed forces. They're of unrivaled gravity and breadth. No other person can just exonerate somebody. You're on death row. Nope, you're pardoned now. An incredibly powerful thing. Quite appropriately, those duties come within the safeguards of the ability to perform his vital functions, which is such a shame that we have such a demented incompetent in the White House with this power. It belittles the whole thing. Additionally, the public looks to the president as the leader of the nation for guidance and reassurance, even on matters over which the executive branch or the federal government as a whole has no direct control. From the actions of Congress to the judiciary, to the policies of state and local governments, to the conduct of private corporations and individuals, the president can and must engage with the public on matters of public concern. Thus, even when a president's actions, and see what they're doing here, they're going to try to make it very difficult to distinguish between Trump's personal life and the presidential life, Trump's official duties and Trump's other personal duties, which may have been outside the scope. Thus, even where a president's actions are, quote, directed toward the constitutional responsibilities of another branch of government, or where he bears no direct constitutional or statutory responsibility at all, his actions are often still within the outer perimeter of his duties, okay? In other words, don't think that the Constitution, everything that's defined in Article 2, is it. Well, it says here in Clause 4 that you can do this, and you did not that, and so therefore it's not within the No, okay? The outer perimeter is the end of the hula hoop, and it's monster, okay? It's not 1 inch, it's like monster. This is one of the biggest hula hoops on the whole planet. It's the president. The amount of power is insane. I mean, quite frankly, in other places, you'd say, you can really do that? That's pretty amazing. It is. Why do we give the president so much power? Guess what? Because we've got 2 other co-equal branches of government that check and balance the president. That's why. They have it, but unlike other monarchies or tyrants, they have major checks that are literally just as equal, and there's 2 of them. So without question, the president occupies a unique office with powers and responsibilities so vast and important that the public interest demands that he devote his undivided time and attention to public duties. And on our locals and YouTube members only morning streams, we often look at the president's schedule and laugh at how empty it is, as it was today. As the Supreme Court held, the higher post, the broader the range of responsibilities and the wider scope of discretion that it requires. And as the highest of all posts in this country, the presidency warrants the broadest possible immunity, and acts must fall within its outer perimeter unless clearly established as beyond his duties. immunities. In other words, the default is it's inside the hula hoop, not out. In deciding now, how do we distinguish what conduct falls within the hula hoop? Courts apply an objective test based on the nature of the act, okay? The nature of the act, not the manner in which the act was conducted or any other allegedly malicious purpose. So when we ask ourselves what is within the scope, what's outside the scope, what's in the hula hoop, what's outside, the standard, what is the nature of the act? The immunity, they cite another case from District Court, 1997, Sixth Circuit also, says the immunity is not overcome by allegations of bad faith or malice, nor is immunity defeated by an allegation that the president acted illegally. An inquiry into the president's motives to determine whether a particular action was done in furtherance of a legitimate function or for nefarious reasons would be highly intrusive. You see that? You don't even get to go inside into the mind of the president and get to decide. It's his mind. It's his judgment, not yours. So if you try to decide what his motives were, that's substituting your discretion for his. It would impermissibly subject the president to trial on virtually every allegation that an action was unlawful or was taken for a forbidden purpose. It would open the floodgates. You could prosecute a president and question his motive for everything. The Supreme Court has repeatedly emphasized this point because it's obvious. They said it in Fitzgerald. The allegation of malicious or corrupt motives could always be made in every single case, so it's not useful to ask that. And if the motives could be inquired into, judges would be the same subjected to the vexatious litigation upon the allegations, whether the motives were real or not. You just make them up. As Judge Learned Hand said, and Judge Learned Hand was a Southern District of New York judge who is one of the most, if not the most, quoted judge in America, says, the immunity decisions have indeed always imposed as a limitation upon the immunity that the official's act must have been within the scope of his powers, within the hula. And it can be argued that official powers, since they exist only for the public good, never cover occasions where the public good is not their aim, and hence that to exercise a power dishonestly is necessarily to overstep its bounds. So the judge says, a moment's reflection shows, however, that that cannot be the meaning of the limitation without defeating the whole doctrine. What is meant by saying that the officer must be acting within his power cannot be more than that the occasion must be such as would have justified the act, if he would have been using the power for any of the purposes on whose account it was vested in him. Okay, so a very long way of saying that if the president had the power to do the thing and he did the thing and it seems like he could have done the thing, that's enough. You don't get to go in there and say, oh, but why did he do the thing? Oh, in other words, to apply it to this case, Trump was allowed to go investigate fraud. Why? Because he's the president, and the president executes the laws of the country, and we don't want fraudulent elections. All allowed. Now, for Cheney or for Biden or for any Democrat to say, well, we think that he was really investigating fraud because he just wanted to win the election. That's true also, okay? But you don't get to say that the first reason is invalid and substitute it with yours. Both might be true, but the immunity applies because as the president, we don't question his judgment. You can do that at the ballot box if you'd like. They say the outer perimeter of the president's official responsibility would shrink to nothing if a plaintiff, merely by citing official acts that were a part of an unlawful conspiracy, could bring a whole slew of charges. Nor, writes Trump's defense, nor does a mere allegation that an act was unlawful or otherwise inconsistent with some particular scheme place it beyond the outer perimeter of the hula hoop. They gave us the Fitzgerald example. Here, a federal employee working for the Air Force argued that Nixon exceeded his official responsibilities when he fired him. The court, though, rejected that argument. They said, sorry, Nixon's general constitutional and statutory authority to oversee the Air Force placed the nature of his acts comfortably within the outer perimeter of his conduct, therefore absolute immunity. The Supreme Court said if we hold otherwise, the president would be subject to trial on virtually every allegation ever, and therefore it would deprive absolute immunity of its intended effect, and therefore we're not going to allow it. So Trump says for the same reasons, alleging that immune acts were a part of a conspiracy doesn't defeat the immunity. You don't get to just say that when you bundle up all of these different claims that now we can say there's a conspiracy and there's a crime and that immunity evaporates. evaporates. Immunity applies to all of them. They say, importantly, this recognition of absolute immunity, regardless of the internal motivation, does not place the president, quote, above the law. Sorry. Instead, it simply clarifies that the remedy for the alleged official misconduct lies, as the Constitution requires, with Congress. They've got to impeach him, and then they can go from there. And there's other informal means as well. But prosecuting your political opponents is not one of your options. Never has been. Not for the 234 years of our country's existence. But when you're being taken over by communists who want to just reshape the country, prosecuting your political opponents is a nice they're very familiar with. We're seeing it in other parts of the world now. It's here. So presidential conduct with both official and private character is immune. How do you disambiguate the two? Kamala Harris loves Venn diagrams and buses with USB ports. She can't stop talking about them. So what happens if Trump is protecting the nation against fraud, and the benefit of protecting the nation against fraud is that Trump wins the election? Should they prosecute him now for that? Because he got a benefit? Well, no, because it's immune, because it was his official conduct. Trump's defense. Because of the unique nature of the presidency, the president's exercise of his official responsibilities may have personal ramifications and vice versa. As the Supreme Court has recognized, it's commonplace for the president's speech and the conduct to have dual roles, both roles of an official and a personal character. They say, the Supreme Court, that the president is the only person who alone composes a branch of the government. As a result, there is not always a clear line between his personal and his official affairs. Thus, for any president, the line between the official and personal can be elusive. It can be difficult to discern. Now, the government has recently agreed with this point in another case before the D.C. Circuit. They said that a first-term president is, in a sense, always a candidate for office, and it is not the least bit unusual for first-term presidents to comment on public policy or foreign affairs at campaign events, or in this day and age, to announce policy changes by a tweet. That was from another case. Apparently, the government filed an amicus brief, and so they went and found that out. So defense says, for example, the announcement of a presidential policy decision at a political rally or comments on foreign policy at a campaign event cannot categorically be excluded from the scope of the president's office merely because he made them where he made them. Just because the president walks out onto a campaign floor and says something doesn't automatically mean that everything is now off limits in terms of immunity. Other statements at such events may be understood by members of the public as reflecting the official views of the president and not just remarks of a political candidate. Okay, like the president doesn't come out with like two different hats on and he says, okay, now I'm going to put on the official president hat, pop this one on, this is official policy of the United States, and then take it off and say, okay, now I'm candidate Trump, and here's what I'm going to do. It's insane. Okay, there's a lot of overlap between the two. So for this very reason, it is not appropriate to frame the immunity question in terms of whether the challenged conduct of the president was undertaken with a purpose to secure or perpetuate the incumbency. In fact, the Supreme Court has emphatically rejected an argument that otherwise official acts lose immunity if they're motivated by an impermissible purpose. That logic applies to even greater force to the suggestion that the president should be subject to suit whenever those acts are motivated by electoral or political considerations. Thus, even if the president's speech or conduct appears to have a dual character, both official and personal at the same time, the conduct still lies within the outer perimeter of his official responsibilities and it's immune from prosecution. So, Venn diagram analogy. Yeah, it may be in the candidate circle, Kamala, but it's also in the official responsibility circle. And that's fine if it's in two circles, but it also gets the immunity from the first circle. So every act alleged in the indictment, they say, this is Trump's defense, it falls within the outer perimeter of the presidential duties, and every single act is immune from criminal prosecution. So now that we've got the conduct, now that we've got the tests, they say, let's apply this, baby. Every action of Donald Trump that's alleged in Jack Smith, Joe Biden's indictment falls within Trump's official duties. As an initial matter, every action of Trump charged in this indictment occurred while he was still in the office of president. Just to be clear, he was the president at every single moment that every one of these acts is alleged. And according to the prosecution, every single act, all of them, concerned a federal government function. And so given the all-consuming nature of the presidency, these facts alone, that's it, support the notion that the indictment here is based solely on Trump's official acts. We don't have to argue that. He was the president. The indictment itself is listing the official acts. So they say, Your Honor, Judge Chutkan, as we continue our motion to dismiss, we want to make some arguments as to why we think you should do it. Making public statements, especially when they relate to a core federal function, are absolutely within the scope of Trump's official duties. President presidents have a duty to constantly defend themselves and to inspirit the population. And so the presidential function includes speaking. The Supreme Court also held that communicating with the public is standard government practice and it's well within the scope of official duties. So the act of speaking, and we went through a whole litany of things that they say Trump said, all of those statements are within the official duties. Notably, immunity lies even if the official public statements are false and even if they're actuated by malice, which of course Trump denies. Trump's saying, I was here telling you honest things about what I thought the election involved, but they're giving us other standards, saying that in another U.S. case, you might even have actual malice in your statements. Like you could actually lie and be monstrous and evil and you still might be immune. The conclusion applies even more strongly to the president. The tradition of the presidents making public statements on matters of national concern arose in the first days of the presidency, and it encompasses some of the most historic presidential actions in American history. Writing to Judge Chutkan, but really the Supreme Court, they say including George Washington's farewell address and Abraham Lincoln's Gettysburg Address. Theodore Roosevelt described the president as a bully pulpit for advancing policy views and matters of public concern. And when a president speaks to the public on matters of public concern, especially issues of uniquely federal concern, like, federal elections, those statements fall within the heartland of his or her official duties. And still today, the government recognizes the statements from the bully pulpit as a fundamentally presidential act. They said this at the Supreme Court. They said the traditional bully pulpit of the presidency is not limited to speech concerning matters for which the president bears constitutional or statutory responsibility. Not just that, but instead it includes matters over which the executive branch or the federal government as a whole has no direct control. It's very broad. It's all important to the powers of the presidency. And they've emphasized that a government entity has the right to speak for itself, including the president. And so for the same reasons, Donald Trump posting tweets on matters of public concern that relate to federal election is within the heartland of his official duties. A tweet is a public statement in a different, and it's even a more accessible forum than others. The fact that Trump most often communicated through Twitter rather than press releases or public speeches is a different medium, not a different function. Now, they say, although addressing a different set of allegations, this court, meaning Judge Chutkan, recently concluded that some of President Trump's tweets and public statements about the certification process did not fall within the outer perimeter of his official duties. Judge Chutkan said that in a different case called Thompson. However, Thompson addressed a different set of allegations and it's distinguishable. And also, it's non-binding and it's unpersuasive. So they're saying there's another bad case out there the D.C. Circuit has ruled on issues, maybe not Chutkan. They say Thompson acknowledged that Trump's pre-January 6 tweets, regardless of what you think of the outcome, the statements that he made were plainly matters of public concern. The public was obviously interested in not having a fraudulent election. The defense continues, they say, the analysis should have ended there, as speaking to the public on matters of public concern about federal concerns, that's the end of it. They're distinguishing a bad case, and so we'll fast forward through that. They say here, as to the second bucket, not only was Trump posting tweets, which are presidential communications, and the president can communicate using the bully pulpit whenever they want, meaning it's immunized, there was also a separate category of conduct. This was Donald Trump talking to the DOJ. They say the president's alleged meetings and communications with the DOJ is literally within the Constitution. Article 2 says the president, quote, shall take care that the laws be faithfully executed. The laws include prohibitions against election fraud, and other election crimes. And a bunch of people are involved in preventing this. In fact, the DOJ has an entire election crimes branch, all right? They created that in 1980, and they consult all over the place. So there's a whole division. In short, it is indisputable that the president can enforce election laws through litigation, and urging his own DOJ to do more to enforce the laws is unquestionably an official act of the president. It's his Department of Justice. Deliberating about whether to replace the acting attorney general is also a core function. He's allowed to do that. The appointments clause under Article 2 says that the president has that power. And during the first Congress, James Madison stated that if any power whatsoever, its nature executive, it's the power of appointing people. So Trump has full right to decide who is on his team. The next category, meeting with state officials. Could Trump have exceeded the scope of his protection by calling Brad Raffensperger or Rusty Bowers in Arizona? The defense says no. They say next, meeting with state officials about the administration of a federal election and urging them to exercise their official duties is a core exercise of presidential responsibility. The Supreme Court long ago rejected the notion that the presidents take take care duty is limited to official acts of Congress or treaties. Okay, the president has a lot of authority, and ensuring the integrity of federal elections and urging state officials to take steps ensuring federal election integrity is literally within his official duty. Taking steps to ensure that fraud and other irregularities do not vitiate the outcome is also within his duties. And so the indictment in this case alleges that Trump communicated with state officials and that Trump argued that election fraud occurred, and he encouraged them to conduct their own investigations and then to take steps to address those issues. All sounds like something you might want a good executive to do. I want you to investigate the fraud. When you find it, make the corrections. Those are just the sort of communications that the DOJ would do if it had investigated and concluded that there were other fraudulent activities in the states. As noted above, the Elections Crimes Branch of the DOJ, they consult all over the place, but the DOJ's authority is not greater than the president. So because the DOJ looked into it and said, oh, Bill Barr, yeah, we found no problem, and then he resigned, right? They say that the president still has ultimate authority. So the president thus has the authority and the obligation to communicate his concerns to the relevant state authorities. He's allowed to do that. Now, the DOJ has recently come to the same conclusion. They've concluded that communicating with state officials about their duties is within the scope, and we saw that in Nixon versus Fitzgerald. So, as a general matter, we know that a president may communicate with federal election officials about election integrity concerns, but the prosecution through Jack Smith attempts to sidestep this issue by falsely alleging that President Trump did not really believe, in italics, did not really believe that there were outcome determinative issues with the election. Trump really didn't believe his stuff, okay? He was getting high on his own supply, as MSNBC says. However, probing President Trump's internal beliefs, again, are questions of motive or purpose that cannot defeat immunity. If they could, the president would be on trial for every allegation that anybody thought was unlawful or was taken for a forbidden purpose, which would basically be anything. They say another case came to a different conclusion and we distinguished that, but the president's duties include the specific rights that come out of the Constitution itself. And they say Thompson, this other case, is a bad formulation and that it would undermine the bedrock functions of the government. Trump's defense continues. Trump also talked to senators and other congresspeople. They say that's perfectly allowed. He talked to Vice President Mike Pence as the president of the Senate. Presidents routinely talk to people in Congress. Oftentimes they invite him into the White House. This has been rooted in our nation's history for a long time. President Trump directed his communications in this case to Mike Pence. Mike Pence was the president of the Senate at the time. Very central to this entire operation. The Constitution assigns the president, extensive roles in this process, including and other powers. But what's particularly relevant here is the president's authority to recommend to Congress consideration of measures as he shall judge necessary and expedient. Here, the executive branch endorsed this back in 1960, and we're getting a lot of the rules here, but we fast forward. In this case, the indictment alleges that Trump urged both Vice President Pence in his legislative capacity as the president of the Senate in this indictment, okay, Jack Smith's specific conduct, and members of Congress to exercise their authority in election certification proceedings. They say it's consistent with Trump urging things for the public good. The conduct is manifestly part of the president's responsibilities. And the question whether the president has a formal role in the election certification process makes no difference. As the DOJ recently put it, a president acts within his scope of office when he urges members of Congress to act in a particular way. A president lobbies Congress to do things, even if it comes to a legislative matter or particularly with a legislative matter. Even a matter like a congressional investigation in which the president has no constitutional role. So the president can use that office to communicate and do things that are in the scope of his office. In fact, there is direct historical precedent for a sitting president communicating with members of Congress about election fraud. In the wake of the 1876 election, here's one example. President Grant Ulysses discussed the electoral count and the claims of fraud with a member of the U.S. House. Somebody wrote an article about this. Likewise, President Grant also transmitted to Congress a letter that he got from a U.S. senator whom he had requested to go to New Orleans to witness the counting of the votes. Yeah, Ulysses S. Grant is the president. And they're talking about similar issues back then, after the Civil War. President Grant also dispatched federal troops to Louisiana and Florida to prevent violence, while Republican-controlled election boards counted votes. And he instructed the federal troops to report fraud in the election. These acts, just like President Trump's, were presidential. Well, nobody prosecuted him, okay? He didn't have Joe Biden and the lefties, led by, who knows, Barack Obama or whoever, leading the charge to prosecute Ulysses. He only had Robert E. Lee and the South. Okay, but he didn't have Fannie Willis or Tishy James, which is a whole different beast. So here, allegedly, they wrap up, they say, allegedly organizing alternate slates of electors also is immune. The indictment alleges that President Trump directed other people to create slates of electors. The indictment from Jack Smith clearly alleges that these actions were part and parcel of Trump's alleged attempts to convince Pence and Congress to exercise their official authority in his favor on J6. They're saying in the indictment that they were caused to transmit their false certificates and their false submissions to delay the certification. Trump's defense says, are you kidding? These actions fall within the president's official responsibilities for at least two reasons. One, as noted, the outer perimeter of the president's official responsibilities includes the rights, duties, and obligations growing out of the Constitution itself and all the protection implied that results. The Constitution explicitly provides for presidential electors, and it delineates their role. It's in their Article 2, Section 1, Clause 2. Now, while presidential electors are not officers or agents of the government, they do exercise federal functions under the law. The indictment itself from Jack describes the selection of the presidential electors as an integral part of the bedrock function of the United States. We all recognize it's important. It's in the Constitution. We have electors nominated. That's the Electoral College function. And so the organizing, the slates of electors, it therefore directly relates to the rights, to the duties, and to the obligations growing out of the Constitution itself. And thus, it is within the president's responsibilities. So without contingent slates of electors, there would be no alternative option for the vice president to certify. You hold your place in line. The alternate selectors are there. They're alternates in case there's a challenge. You don't just give up. Okay, if you run a race and both people cross the finish line and we have a photo finish, everybody declares victory. Everybody does, until somebody comes out and makes a decision, right? The photographic evidence comes in and makes a decision until that photograph is rigged by the CIA and the FBI. So there would be no alternative. They have to lodge their complaints until it is officially certified. We got to the end game and Trump left. So it would render futile any efforts to urge Congress to consider fraud and irregularities. Anytime there's fraud, if the party that alleged the fraud just said, well, you know, I give up. You guys win. Good game. And you just go ahead and are victorious. We'll just sit this one out. That would obviously result in more fraud. Okay, the people who would just win, it's the first past the post would win. You challenge it until it's settled. So organization of slates of electors, in other words, says Trump's team, advances two core presidential functions. One, protecting the integrity of the federal elections, and two, urging members of Congress to act in a manner consistent with the president's view of the public good. Thus, these actions from Trump clearly lie within the outer perimeter of the president's official responsibilities. And second, as the indictment itself emphasizes, the actions of organizing slates of electors were ancillary and they were preparatory to the acts of communicating with Pence. The acts of communicating with Pence were themselves core exercises of presidential responsibilities. So Trump's team says, Your Honor, acts that are intertwined with immune actions are themselves immune. So if you're going to try to create this jumbled mess of some non-immune and some immune and mash them together, they're in the same Venn diagram circle. They're both immune. For example, it's widely accepted that absolute prosecutorial immunity will attach for a prosecutor. They say, thus, a prosecutor who performs functions within a continuum of initiating and presenting a criminal case ordinarily would be entitled to absolute immunity. So just like prosecutors as well, Trump's alleged acts regarding these slates of electors are performed within the continuum of his other immune acts, like talking to Congress as well. And so Trump's team wraps up a whopper of emotion and quite good. They say, for the reasons articulated above, the acts alleged in the indictment lie firmly within the outer perimeter of the president's official responsibility, and therefore they cannot form the basis of criminal charges against President Trump. Therefore, in conclusion, the court should dismiss the indictment with prejudice on the grounds of presidential immunity. Signed, sincerely, your friends, John Lauro and Todd Blank. avalanche. Great motion. Now, I think, as I said, we're not going to see the end of this. My suspicion is we'll get the Jack Smith response, and then Judge Chutkan will summarily the motion to dismiss, and we will see this go away. Trump will then at that point have a question about an appeal and whether that gets certified by Judge Chutkan or the Court of Appeals to pause the criminal case right now, I think is also a long shot. So more likely than not, this would be something that we appeal after the conclusion of the criminal case, unless Trump decides to just go directly to the Supreme Court in some other manner. But very good motion. And I really liked how comprehensive it was. And you'll notice some of the things that we didn't see in here. We didn't see some things about other prosecutions, like we didn't see double standard talk. Okay, we didn't see anything, well, Hillary's not being prosecuted or anything like that. And we didn't really get into the specifics of the election itself. We didn't talk about fraud specifically. We didn't actually ask, was there fraud? We didn't talk about FBI or the DOJ, like what happened there. It's all about the president's power. Does he have the ability to articulate these positions? And of course, I think that he does. He's the president for a reason. And the president has root power. It is the source power of the executive branch in the United States. And the Democrats, by this prosecution, have shattered and wrecked 234 years of American precedent, all because they want to take out Donald Trump. And so thank you for joining us as we carry on, because this case is only getting started. Jack Smith will have a reply. We'll get it, and it will continue on. But Donald Trump files the motion to dismiss, and a good one. Go into SCOTUS. We'll be there to cover it as well, and we'll see you on the next one.